From twisted lies to shocking abuse of power, these so-called officers thought their badge would save them until the judge stepped in. Watch as justice is served cold and these corrupt cops get absolutely owned in the courtroom.
Under our version, both hands were visible and he had nothing in his hands and he was shot twice and killed.
In 2016, Officer Osvaldo Villarreal found himself in court, not for the shooting itself, but to claim qualified immunity after killing Benny Herrera in 2011. The family's suing, and now the judge has to decide. Was it justified or just plain wrong?
But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He kept his hand in the front pocket of his hoodie sweatshirt. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
What you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Well, I don't recall at what point his camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see.
Officer Villarreal pulls up, tells the guy to take his hands out of his pockets, and boom, not even a full second later, he fires twice. Just like that. No warning, no patience. The family's calling it what it looks like, a trigger-happy cop hiding behind a badge.
That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, take your hand out of your pocket, and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision. Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. That's when Officer Villarreal had to decide, is he doing this peacefully, or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make that decision.
Well, don't we have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
Benny Herrera was completely unarmed and posed zero threat, yet he was still gunned down. Shockingly, the officer was cleared at first, but after reviewing the body cam footage, the judges believed he had no business wearing a badge.
Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it significant that Officer, is it Miali?
Miali.
Chose not to fire? I mean,
because
it seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And
right.
they're gonna say, no, He simply had his hand in his pocket, and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to take their facts, not the facts as you want. You got to stick with their facts and explain why under their facts you win as a matter of law.
I agree, Your Honor.
If this had been anyone but a cop, they'd be facing murder charges, no questions. The lawyers' arguments were full of holes, and every judge on the panel seemed to lean toward Herrera's side. It looked like Officer Villarreal was about to lose his qualified immunity for good.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case,
right,
at this stage, we have to accept their version of the facts. So you need to explain under their versions of the facts why, as a matter of law, you win. We take those facts. Yes. You're saying that, as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The judges weren't holding back. They asked all the right questions, and the attorney was clearly scrambling. Even worse, she tried to pass it off as a reasonable mistake.
I'm sorry, Your Honor, I don't believe that I'm familiar with the Espinosa.
Well, in Espinosa, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor. Espinosa versus City and County of San Francisco?
Yes. But here, the domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't
threat.
think anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
But the attorney wasn't done embarrassing herself, and the judge was ready to make it worse. The panel then called up the plaintiff's attorney to lay it all out. Why this officer doesn't deserve qualified immunity.
But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
The plaintiff's attorney came in swinging, calm, sharp, and fully prepared. She tore the officer's story apart. The defense made one last desperate plea to keep qualified immunity, but by then, things were looking rough for the trigger-happy cop.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial, the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right. I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
Soon after, the judges dropped the hammer, qualified immunity gone, and the trial was on the way for using unlawful deadly force. The city paid Herrera's family $1.4 million, and Officer Villarreal fired.
I think we're done. At this point in time, I think we're done.
Buckle up for this, cause the man in the hot seat isn't your run-of-the-mill repeat offender. It's former Sheriff Todd Pate. That's right, the guy who used to enforce the law is now breaking it, charged with assault, a second DUI, criminal mischief, and fleeing the scene.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
Then is it your intention to enter a guilty plea at this time or not, sir?
No.
4 people injured, 1 former sheriff behind the wheel, and then poof, he vanishes. That's the scene Todd Pate allegedly left behind after causing a wreck and driving off. When police finally caught him, his blood alcohol level was double the legal limit.
Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
And just when you think it couldn't get messier, Pate says that assault charge, total revenge move. He claims it was slapped on just because he used to wear the badge and had the guts to turn down the prosecutor's plea deal. Sounds less like justice, more like a grudge match.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
Is it your intention today to enter this guilty plea?
And if I could address...
Okay, this is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it. Probably
I think
unusual,
we're done.
but
At this point in time, I think we're done. Where I think we are today is that on the one hand, the Commonwealth can enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time.
Ma'am.
We're done at this point in time. He's going into jail today.
In the end, Pate took the deal, pleading guilty and scoring a 75-day county jail sentence thanks to credit for time already served. From the sheriff's office to jail cell, talk about a full circle.
I received a call of a female down. She was barefooted. She was face down. She was brutally attacked.
Next up, we have former Border Patrol Supervisor Ronald Burgos Aviles, who goes on trial for something unthinkable, the brutal murders of Griselda Hernandez and their 1-year-old son, Dominic Alexander.
That morning, more or less around 11:30, paramedics, the ambulance was already parked outside. I parked and I walked down to the trail.
Okay, did you come in contact with anybody when you got there?
Yes, while on my way down, 2 paramedics were on the way up, and I asked them, more or less, where is everybody? They said, follow the dirt trail, and you'll see the body, and you see the USBP agents down there.
Okay. Did you come in contact with a BP agent by the name of Dennison?
Yes, sir.
Over 20 witnesses took the stand, family, friends, cops, and even forensic experts. One of them, Officer Alberto Cortez Jr., recalled the chilling moment he arrived at the scene after a call about a woman found with deep head wounds.
This is where BP units were stationed. 4 to 5 United States Border Patrol agents were located here. And a motionless, lifeless female body was about right here. She was facing eastbound. And upon me being a police officer, secured the crime scene, to look for any evidence, any clues, anything out of the ordinary. As I began to canvass the crime scene, in better words, I was walking around this grassy on the edge. There was one USBP agent, Agent Dennison, already ahead of me. He was already south. I passed the female body. I did look at her. I observed she was barefooted. She was face down. Lots of blood. Can you hear me? Yes, lots of blood around her upper middle torso on the dirt. And continuing my path southbound, I saw blood drops on the dirt. At this time, Agent Dennison said out loud, I found another body.
Okay. Is this the type of blood that you saw?
That is correct, sir.
You also said that there was, and you didn't walk on the, where were you walking? Let me ask you that much.
On the grass, where the grass and the dirt meet, right on that
So you stayed on the
boundary.
edge of the path?
Yes.
You did not disturb the dirt path?
No, sir.
Okay. Tell the ladies and gentlemen of the jury, were you the first officer that arrived?
Yes, that is correct.
So you were the first official Laredo police officer to arrive,
Yes.
and this location falls within your jurisdiction?
No. Each officer is assigned a certain area. I got dispatched
Okay.
to be there.
No, but what I'm saying, that's within the city limits.
Oh, yes, that is correct. Yes.
Okay, so this is within the city limits?
Yes.
What county is this?
Webb County.
So the body's in the city of Laredo and Webb County.
Yes.
What do you do as the first responding police officer?
First thing is obviously a crime scene is secure the crime scene.
And what does that entail?
To preserve as much evidence, not to let anyone of unauthorized personnel try to destroy any evidence. So therefore, us officers, we have crime scene tape, the yellow crime scene tape. So I began to secure the crime scene tape around the grass area.
So you are the person that put the crime scene tape up that morning?
Yes, that is correct.
Okay.
What came next was chilling. The officer had just found something far worse, and the case took an even darker turn.
What was your impression of what had happened?
Any prudent person will see a lifeless, motionless body to come to the conclusion that she was deceased.
But at that time, the opinion as to how she was deceased based on what you're seeing, what you're assessing, are you making an assessment?
No, she was brutally attacked.
You also testified that he said that there was a body.
That is correct.
Okay. What happens at that point? Or what do you do at that point?
At that point, he was ahead of me, southbound. When I heard him say, I found another body, I walked towards his direction, to his location. He was no longer on the dirt path. He was in the brush. And when I arrived there at the brush, with Agent Dennison, I observed a motionless little boy as well. Of course. Little brown booties, little brown boy booties, blue jeans that were covered in blood, freshly haircut, and what caught more of my attention was the way the body was positioned, he was placed. He wasn't thrown, he was placed. It's as if someone had placed him down.
Did you see any injuries to the baby?
Yes, lots of blood around the neck area, and that came down. I said again, blood on the blue jeans as well.
And you recognize this?
Yes, now I remember the t-shirt. Yes, sir.
Did you see any other injuries on the baby? How close were you to the baby?
Standing right over the body.
How many injuries did you observe on the baby at that time?
I only observed one,
And that was to,
the neck area.
did you notice any cuts, incisions, or tears on the shirt?
No damage, just the blood.
So the shirt is intact?
Yes, sir.
The baby you said was wearing jeans?
Yes, sir.
And I'm showing you State Exhibit 25. You said you recognize these jeans,
Yes.
and you said that he had a large amount of blood on it. And what was the conditions of the jeans?
Blood-soaked jeans.
And finally, you said that he was wearing, what was he wearing on his feet?
Brown booties, brown little boy booties.
State's Exhibit 24.
Yes, sir.
Officer Dennison had made the grim discovery, a second body, this time a lifeless little boy later identified as Dominic. Heartbreaking doesn't even begin to cover it. While the officers were shaken, the child's father stood cold, completely unfazed.
Agent Dennison was in front of you this whole
Yes,
time?
he was with me. Yes, yes, sir.
And you were with him when the shoe was found?
Yes, sir.
Okay. What communication came over the radio that morning?
It was broadcasted, possible suspect, Burgos. That was broadcasted over my P unit, portable unit.
What was your reaction at that time? But when you heard Burgos, what did that, did it mean anything to you at all?
No, no, sir.
Did Dennison?
Dennison was in close proximity where he could hear the broadcast on my radio.
The name Burgos comes out.
Yes, sir.
It means nothing to you.
No, no, sir.
Do you see a physical change in Agent Dennison?
Yes, sir.
To you, what do you see this physical change?
He was in shock.
And then came a red flag Cortez couldn't ignore. He overheard Burgos being named a suspect. Officer Dennison was nearby, and his reaction? Not shock, not confusion, just a chilling sense of figures.
And you saw Mr. Burgos there at the scene as well?
I saw many of them, yes. But sitting here, I recognize him, yes.
And he appeared to be in shock as well as Agent Dennison, correct?
No,
That was not your impression?
no, no, sir.
So you're saying that he appeared to be normal to you?
Yes, sir.
All right. No further questions, Your Honor.
Then came the real gut punch. Cortez revealed that Burgos showed zero shock, zero remorse when he got to the scene. Nothing. Like he hadn't just lost a child or committed something unthinkable. As always, thanks for watching. If these cases had you on the edge of your seat, don't forget to hit that like button and subscribe for more jaw-dropping courtroom drama. See you in the next one.